Hello everyone, my name is Todd Rosenfield, the founder of the Socius Law Firm. Welcome to our Take 10 webcast on the top 5 reasons to avoid probate. Before we begin, let's take a quick look at what we'll cover in the next 10 minutes. First, we'll talk about the probate court. Next, we'll discuss death probate and what it means to you and your loved ones. Then we'll discuss the top 5 reasons to avoid probate. Then we'll wrap it up with some other key considerations regarding probate avoidance and estate planning. One of the most common reasons people turn to me for estate planning is to avoid probate court. So what is the probate court? Well, in Massachusetts, the Probate and Family Court Department has jurisdiction over family-related matters. This includes guardianships and conservatorships and wills, estates, and trusts. Generally speaking, this means court oversight over these matters. And if you've done no planning at all, you are guaranteed to have to go to probate court. In terms of estate planning, there are two types of probate to consider: living probate and death probate. While the focus of today's Take 10 webcast is on death probate, I think it's important to briefly mention what living probate is. Without any planning, if you became incapacitated for any reason, someone would need to file a petition with the probate court to be appointed as your conservator to make financial decisions on your behalf. Similarly, someone would have to file a petition to be appointed as your guardian to make medically related decisions on your behalf. This is known as living probate. In either case, understand that you have no control. The probate court maintains total control over this process, despite the fact that a decision may need to be made on an immediate basis for your benefit or your loved ones. A delay can be disastrous. Moreover, this completely avoidable process can be very expensive. Okay, so now let's discuss death probate. What is death probate? Death probate is a court-supervised legal process that may be required after someone dies. Probate gives someone, usually the surviving spouse or other close family member, authority to gather the deceased person's assets, pay debts and taxes, and eventually transfer assets to the people who inherit them. The idea behind the probate is that the deceased is no longer around to manage his or her property. So a judge oversees the proper transfer of ownership to the decedent's property in accordance with his or her will, or if there's no will, in accordance with Massachusetts law. It's important to understand that probate is the only way to properly transfer the decedent's assets. Now, you may be wondering, why do we want to avoid death probate? So here are my top 5 reasons to avoid probate. Number 1, the probate process takes time. It can last as long as 2 years. Number 2, and during this time, your loved ones may not have access to estate assets. Number 3, the probate court maintains control over the process. Number 4, probate is public. This means everyone can learn the size of your estate, as well as the names of your beneficiaries and the amount of money they just inherited. For a family that values privacy, this is not an ideal scenario. And number 5, death probate can be very expensive. The average cost to administer an estate is 3 to 5% of the estate's gross value. Another thing to keep in mind, as many people have vacation homes or assets in other states, is that your family could face multiple probates where these assets are located. So I think the best way that I can convey the importance of avoiding probate is to provide an example. As I mentioned earlier, probate is a process that we must follow along with court oversight. The very first step in this process is having someone appointed as a personal representative of the decedent's estate, also known as an executor or administrator. On November 10, 2016, I filed a petition to probate an estate. The decedent, a very young man, was survived by his wife. They had only been married a few years, and most of their assets were in his name alone, including their house. In the probate petition, the wife asked the court to be appointed as representative of her late husband's estate and asked for permission to take control of and inherit his assets. Nearly 2 months later, I received this letter. If you can see the highlighted portions, it states, "However, Due to staffing shortages, we are unable to reach out on an individual basis at this time, and below, due to the complex nature of these cases and staffing shortages, we will not be able to handle these issues by telephone. Now, I can tell you there was nothing complex about the matter that generated this letter from the Middlesex Probate Court. Nonetheless, I had to appear in court, causing more delay, costs, and expenses. As you can see, 5 months after having received the previous letter, and having previously appeared in court to address a very simple issue to the court's satisfaction, we received the very same letter. And once again, I had to appear in court, resulting in further delay and unnecessary costs and expenses. Then finally, in July 2017, 9 months after filing the original petition for probate, the court approved my client's request to be appointed personal representative to her late husband's estate. Remember, as I just mentioned, this is only the first step in the process, and it took 9 months. As we wrap up today's Take 10 webinar, here are some key takeaways and other considerations. First, I want to emphasize that probate can be entirely avoided with proper planning. And planning is not something you or your loved ones can do after you become incapacitated or pass away. There are essentially two options when it comes to estate planning: will-based planning and trust-based planning. Although this Take 10 does not allow enough time for us to get into the details, the key point I want to emphasize today is that will-based planning does not avoid probate, while trust-based planning does just that. For more information on will-based planning and trust-based planning, please watch our webinar on wills, trusts, and why estate planning matters, or visit the estate planning section of our website at www.sociuslawfirm.com. We've packed a lot of information into this short webcast, so if you have any questions at all, feel free to contact me. My contact information has been provided on this screen. I hope you enjoyed today's Take 10. Take care.